We've already covered the actual process of juvenile court in the previous chapter. Just a very brief recap, though, so you have a bit of an overview of the process. That the actual process can be thought of as three distinct phases. The first appearance, where the charges are announced, an attorney is made available to the child, and detention is considered. The second phase of the process is what is called the adjudication. This is where the factual basis of the petition is considered. An adjudication is similar to what we would think of in adult court as a trial. It's where guilt or innocence is decided. And in the majority of cases, usually 90% or more, a guilty plea is entered. And finally, the last phase, what is called the disposition, is where the court decides what is to be done. The disposition phase is usually split apart for a later date from the adjudication, so that the court personnel have time to write what's known as a dispositional report for the court to consider as to what to do with the youth. This last phase, disposition, can be critical. The court has many options open to it. Commitment is the harshest of all the options. The court could do anything it thought was appropriate, though, from ordering a dismissal of the case to restitution for the victim, or order the youth to outpatient therapy or a day treatment program. Day treatment programs assure that the youth will attend a school and a counseling program all day somewhere, but then the child remains home at night. Or another alternative could be foster care. Or the court could commit the youth to a variety of residential placements. In most states, the court has the ability to determine what kind of placement the youth is being sent to if the child is committed to the Department of Juvenile Justice. But Kentucky is a little different than the norm, in that Kentucky's statute spells out that once the court makes the determination that the youth shall be committed, that the Department of Juvenile Justice then has the discretion of where they want to place the child. And finally, at the very end of the process, in what's known as the post-disposition phase, the child has a right to appeal their case. An appeal allows the person to ask a higher court, one that has authority over the court that made the original decision about the youth. That higher court can review the case and order the lower court to do something if the higher court determined that the sentence was illegal, or there was an abuse of discretion by the court, or that the law as applied was not legal under the Constitution of that state or the federal government. There are limits to the length of sentence that many youth can serve as well. These limits are created by the level of the offense. This means that a misdemeanor or low-level felony would never receive the same sentence as a higher-level felony. There are similar limitations that may be in effect for juveniles, depending on the laws of the specific states. Kentucky recently enacted such limits so that misdemeanor and D-felony offender youth are not subjected to long terms of residential treatment in juvenile justice youth centers. So that's the end of our first unit. Next unit, we'll look at the theories about why delinquency occurs. Those theories will include individual theories of delinquency. In other words, those that are more psychological, biological, or sociobiological in origins, and also social structure theories, social process theories, and social interaction theories. See you next unit.